So how many out there have the book also?
I have it.
Yeah.
I have it on order.
You got an order? Okay. So let me ask you this. What's everybody having a problem with?
I have the book as well.
What's that?
I've got it as well.
I still didn't catch that. What was it again?
You asked who all has Gilbert's law summaries on trust. I have it.
Oh, you've got it. Okay. The second question was, what does everybody seem to be having problems with? Have you got any questions? We might start out and just have a question and answer. So.
Hello?
Yes. Who's this?
It's Pete in Liverpool.
Pete, how are you?
Tired.
You up too late last night, the other night?
Yeah, it's morning, as Michelle rightly pointed out there. Yeah, it's just about acceptance of value. I don't know how that works or how it could work with the, signatures and everything like that. I know you've explained it one time before, but it was a little unclear, and has there been any progress made on that?
So that's where your confusion is, right there?
Yeah.
Okay, anybody else have a different, I'm just trying to get a feel for what everybody's, might want to be going over.
I would like to possibly know how to handle a state income tax bill.
Okay. Anybody else? Nobody else got any? Or are you afraid to come on and say?
Christian.
Yeah, who's this?
Susan.
Yeah, Susan, go ahead.
How are you today?
All right.
Good. Could you briefly go over the startup in reference to setting up the your UCC properly?
The UCC, you mean in regards to?
The trust, to get started in establishing that properly.
Okay.
And also, did you send out your recording on negotiable instruments?
I think it was on that list, wasn't it? The 21st?
I didn't see the list.
I just sent that out. Did you get a copy of the one I just sent it out today?
No, sir, I didn't. And I checked with a couple other people, and they didn't as well. You did send me the updated phone number today when I asked you for that, which ended up by being the same phone number.
Okay,
no,
maybe
I didn't get to see the list.
Check your email again, see whether or not you didn't get a copy. You might have overlooked it there, but if you didn't get a copy, send me another notification that you're requesting the download links.
Okay.
Chris, to fix that when you first call, remember that one?
Yeah, I didn't quite get it done yet. That's right. Yeah, the 20th on there. Well, how many of us are really talking about or thinking about all the time the relationships that we're forming, on a moment-by-moment basis, day to day? And it's talking about on page 6 on the Gilbert's book there, where it's talking about trust distinguished from similar relationships.
Hey, Christian, this is Mike Shad. You have brought it to our attention, debtor-creditor relationship. We're so tied into it. You ask the question, what's on our mind, and what came to mind, the OID process, the way it refunds all the money back to check account.
Right.
And, an accepted value paid for, because that's where we're at right now. It's 30 days, but I want this behind me. I want a real trust relation and be able to go into my first account, property, a creditor, not a debit.
Right. That's
but short-term goal is I got through the month,
Right. That's kind of where I was going. I just kind of got a feel for what you had some questions on, but really, I don't really think that we're thinking in the right direction. We're trying to solve our immediate problem, and that may fix us in the short term, but that in the long run is not going to get us to where we're going to go.
No, it's a different world. People don't realize that. They're really going to be left behind.
Right. So I think we need to really start thinking more about the relationships we're forming on a moment-by-moment basis. In regards to this page 6 here under section C, where it talks about trust distinguished from similar relationships. And I've read this before, where it talks about bailments and trusts, and it talks about the agency on page 8, and then the big one on page 9, which is the debtor-creditor relationship in section 42. And then they give the example there of the $20 bills totaling $500, that if the transferor hands the transferee a bundle of $20 bills totaling $500, and in case she wants the money in return at a specific date, and if, as is likely, the transferor does not care whether she gets back the particular group of bills or even property directly traceable to them, the arrangement cannot be a trust but is simply a debt. So thus, can repay transferor any $500 and is free to dispose of the particular bills received. And that's the example under the debtor-creditor relationship. So if you take the inverse of that, you need to ask for a specific thing back. And if you ask for a specific thing back, then you're actually segregating the trust res property, and then it will be a trust instead of debtor creditor. But like you said, Mike, everything we're so programmed into is being debtor creditor. We do it without a question. And we need to be asking everything that we're signing our signature to, at least, especially, that we're looking for what kind of relationship we're forming at that moment. Is it a debtor creditor, is it an agency, or is it a trust? And if it's not a trust, we better be thinking about how to form a trust. And the reason why I say that is because since we don't have any lawful money, we can't complete any contract. So we can't really complete a sale or a purchase. So therefore, trust had to come in and fill that void. And if everything has been filled with that void with a trust, then we need to be thinking about whatever we're doing at that moment has got to be a trust. And since we didn't express it to be a trust, they're going to turn around and construe it to be debtor-creditor, and then we're back under the debtor-creditor thing.
Now, Christian, how can it be debtor-creditor when there is no money?
Right. That's the whole fiction lie. It's got to be trust because it's got to be equity. So there really is no debt because there is no money, and you really don't owe anything. Now, that's a mind bend. Just like in the movie The Matrix when the kid was bending the spoon, but it really wasn't bending the spoon. He said, that's impossible. He says, you have to bend your mind. So to make this fit, you really have to have a paradigm shift, an attitude of thinking. You got to bend your mind. So really, it's the relationships that we're forming right then and there. And I came up with a little, like 3 little examples, and I use the example of I give somebody my pen. There's really, if you take out a piece of paper, we want to make about 3 areas on that piece of paper, split it into thirds, say, and I'm going to give you like 3 examples. The first example, in a trust there's 3 entities. We have the grantor, we have the trustee, and we have the beneficiary. We have 3 entities in the trust. They can be 3 separate entities. But now, one entity, in another example, could be grantor-trustee combined, or in another one entity example could be grantor-beneficiary. So, number 1, we have 3 entities, one being grantor, one being trustee, and one being beneficiary. And another example, we have the grantor and trustee being the same, and the beneficiary being another entity. So we have 2 entities there. And in another example would be the grantor-beneficiary in one entity, and we have the trustee. That's 2 entities there. So example 1 has 3 entities. Example 2 and 3 have 2 entities, but they're combined up. Grantor and beneficiary in one, and grantor and trustee in another. So back to number 1. We have 3 separate entities. We have grantor being one entity, trustee being one entity, and beneficiary being an entity. So if I give my pen, I'm going to give the pen to, say, a trustee, another entity. And that trustee then has taken and received the trust res property pen, and at that moment the trust has been formed because it was my intent to form a trust. And the trustee had a present trust res property transferred to him. And it's in behalf of some other party to lend my pen to him. So there's 2. If you're not speaking, or I believe it's on mute out.
Q&A mode is on. Participants may now unmute themselves.
Okay, so now, can you all hear me? Okay, you have to press star 6 to unmute. Can you hear me, Harold? I'm still on? You have to press star 6 again?
Yes, still on.
Okay, that got that background noise cleared up. So back to this number 1 example here. I can either gift something to somebody and I don't expect it back, or I can make a request that I want that property back. There's 2 ways that trust res property can be treated. Either I want it back, or I'm going to gift it to somebody. So number 1 and 3 are similar because a gift, and I don't want it back, is in number 1 and 3. And now number 3 example is where we're going to be making a special deposit which needs to be returned in kind. So if I ask for my pen back, we have really a special deposit, just like the example under that debtor-creditor relationship was there, but the inverse of it. So when I want my pen back, really that's my intent. That's intent of one of the elements in a trust. So if you follow a graph, too bad we didn't have the whiteboard. I could maybe put it on the whiteboard there. But in the second example, if it was grantor beneficiary being in the same entity at the top there, and then down at the bottom, if you drew a circle and put the trustee in a circle and a grantor and beneficiary in a circle, you'd have two circles there. Top circle would be grantor / beneficiary. He's one entity. He's in one circle. And then below that, put another circle, put trustee in that circle. So this is the number 2 example. If you draw a line from the top circle to the trustee circle, that arrow, that's your delivery or your transfer, because you have to give the pen to the trustee, and that's a delivery or a transfer. But remember, in this scenario, we want the pen back. That's the intent. All right, now let's go to a diagram on the number 3 example, where we have another circle with grantor / trustee in it. And then below that, we have another circle below that. That's going to be the beneficiary in that circle. So remember, you have to transfer from grantor to trustee, trust res property. So in this particular example, we have the top entity being grantor and trustee as one entity. There's no delivery that takes place from the grantor to the trustee because that entity is one entity. There really is no transfer there. There is no delivery. So when this grantor says that he's going to be the trustee for this property, really what happens is there's no delivery, there's no transfer, but he's making a declaration. He's making a declaration that he's going to transfer property to himself that he's going to hold in trust for the beneficiary. Now, the moment he gave the declaration, that's when the trust formed, because you can't prove that there was no delivery. It was within himself. There was really no transfer. You couldn't tell when it was. But the only way you can tell was be the manifested intent of the grantor to form a trust would be at that point his declaration. So now you have to draw an arrow from the trustee side down to the beneficiary, and that would be the disbursement. Now this example was, I don't want the pen back. It was a gift, and that was my intent also. Now let's go back up to the first example. Let's draw 3 small circles. One circle is the grantor is in that. Another circle to the right, separate from that, is the trustee within that circle. And then down below, in the middle, like, you could draw another circle, and that's the beneficiary. So the grantor you got to draw a line from the grantor circle to the trustee circle, and then you have to draw a line from the trustee circle down to the beneficiary circle. So now with those examples in mind, think about this. If I gave my pen to someone, and I told them I want my pen back, we just formed a trust at that time, and I didn't know or understand, and none of the other parties knew or understood that we were forming a trust there. Because nothing was said about a trust, no terms of a trust were used, but there was a delivery. And at that moment, all the necessary elements were there, the parties were there, and the entity were there, and then one of the methods of formation was there. And we have a valid trust, although nobody really knows or understands that. And it was my intent that I wanted the pen back. So actions or conduct is really based on the intent, and that's really the key, is the intent of the grantor. And that's going to be demonstrated, his intent. His manifestation of his intent is going to be his actions or his conduct. And his conduct here, or his action, is going to be the words that he spoke, an oral declaration. I want the pen back. So the oral expression was the manifestation of his intent. Now, if I told that party I want my pen back, but let's say that it wasn't my intent that I wanted the pen back, I could just say, here, I gave them the pen. Now I don't have to have the pen back. So examples 1 and 3 are similar because it's a gift. I didn't want it back, the pen. Where number 3, the example there is, that was the gift. That was the special deposit. Wait a minute, I've got that wrong, I believe. No, that's right. That's correct, yeah. Yeah, number 3 is where a special deposit to be returned in kind. Now in Gilbert's it talks about, under that number 3 example there, that when the grantor and the trustee are one and the same, you can't prove a delivery within yourself. And that's when a declaration comes in. And that's about the only time you're going to use a declaration for formation of the trust. Any other time you're going to be using a transfer or a delivery as the formation of the trust. And I've noticed some people were sending me some examples about declarations. Unless you are the grantor and the trustee in this scenario, you can't give a declaration. Well, because you can't take and prove, because the declaration is what's proving within itself, because the point is moot to transfer between grantor and trustee being one and the same. And the only thing that's going to fit that one there is they're going to use a declaration. Well, I would rather prove that by delivery through the transfer by delivery. Well, that was the declaration, a notice of the declaration. Because that's the only way you're going to know that the grantor and the trustee being one and the same, that he actually transfers the property. So he has to give a declaration of some kind to let somebody know that he's holding a particular res property for the beneficiary. So he's going to have to give some kind of recording or notice or something of his declaration. But yet no delivery took place because it was within himself. But it's real. What I'm trying to explain here is the intent was really based on the actions of the conduct, and that was really by the expressions of what it is. I want my pen back, or I don't want my pen back. Like we have all the three entities in all three of these scenarios being the same. But the only thing that's really different is that, if you think about it, it could be a trust, but yet we're not identifying what we're trying to say. It's kind of hard to explain it. These three entities are a good example of, what we should be paying attention to. Because 1 and 3 are similar because they're gifting, and where 3 is the special deposit. Because I'm talking about the pen, whether it did want it back or whether it didn't want it back. So now let's talk about 1933. When we put the gold into a trust. Now the question is, was it our intent that it was a gift that would have been a special deposit and we get it back sometime? But the intent never was expressed. And like I went over on the one show there when we talked about the protective trust and the spendthrift trust, where the spendthrift trust is acting like the Declaration of Independence. And as long as we didn't pay the war debt, if a creditor tried to get at the assets of the beneficiary before he got the property, then it's up to the trustee they're going to form a protective trust, protect the assets so the beneficiary can still have the assets from the creditor. And then they formed from the spendthrift trust, the protective trust, to the discretionary trust on a modern view, where they're construing it to be the modern view that I think is in total disregard of what the Founding Fathers had in mind when they defined it through the Declaration of Independence, that all the rights that we had were unalienable rights, and they specifically named life, liberty, and a pursuit of happiness. And I believe that the documentation will show that happiness was supplanted when it really was property. So it was life, liberty, and property. Well, those were specifically mentioned, along with all the other unalienable rights, and unalienable being not transferable. So in a modern view, they're taking and redefining the terms under a more modern view under public policy, just like it's saying in that section 498, I believe it is, in Gilbert's, on page 140. Under the protective trust, it says the rationale, a protective trust may be intended to reach the result somewhat comparable to, and in fact more secure than, the result of a spendthrift trust. But it is logically less objectionable. Well, less objectionable. I think that's today's public view that's been construed over the years. But it wasn't the will of the grantor who gifted or granted you your unalienable rights. So it's less objectionable in that the beneficiary can be sure of receiving substantial trust benefits only as long as he keeps his debts paid. So we didn't pay the war debt, and they asked for the money, or made it illegal for us to have any gold, and we gave up the gold voluntarily. And that was so that the beneficiary's gold couldn't be taken from them by the creditors who were coming at them, because basically we stopped paying the debt. And we went insolvent. We went bankrupt. And they're holding it in protection under a more modern view now, under the discretionary trust on page 138, section 490, where the discretionary trust is one in which the trustee, that would be the U.S. bankruptcy trustee, is given discretion now to make or apply or withhold, in parentheses there, the distributions of income or principal, or both to or for one or more of the beneficiaries being we the people, whether or not the instrument provides standards for the trustee's guidance. And the Declaration of Independence really doesn't have any standards in the indenture there, other than it says that, period, all our rights are unalienable. I mean, that's pretty simple, I would say, but it's being misconstrued, I think. So anyway, this trustee now has discretion to withhold the distributions, and that's probably a bigger buildup of the bingo of the spendthrift trust, the Declaration of Independence being the spendthrift trust on page 131 under section 460. So the analogy is that what's really holding up our remedies is really because we're still in debt. We're not paying the debt, the original war debt, our fair share of the war debt. And if we would keep our debts paid, the trustee couldn't do the withholding. He wouldn't have the discretion to withhold because there's no creditors coming at the beneficiary to claim any beneficial assets. And it doesn't have to be protected because the beneficiary will get his assets. Otherwise, as soon as they would transfer the assets, the creditor would claim the assets of the beneficiary. And I think that's what they're protecting. So if we come back in and pay our fair share of the debt, then they could distribute the funds to us, and no creditor can come at us and claim because we've already paid the debt. Then we can come back in and get our private credit going, like I said on that Monday call, and we're negotiating the NDIs, although we really aren't negotiating them. We're generating interest on them on the public side against the private asset source side, and we'll live off the interest on the public side and write it out at just like a checking account, and nobody would be any the wiser. So then we could pay our electric bills and our grocery bills. So I think the big question is, okay, going back into how do we go about claiming and paying the debt? I think that's the paramount first thing we need to be doing.
Yeah, that's a big question in my mind.
Has anybody been following the DTC thing with Tony King? Has anybody been familiar with what's happened on recently? Anything? In other words, my question is, has anybody got into the DTC yet?
The last I knew about Tony King was that really his whole story wasn't true. And from what I know about TC, you can enter a master note if you apply, and it's not expensive. You just have to get past the eligibility. So I don't know, what Tony King thought he had this big, secret way in there. I mean, it's a form. I think fill out the form and go in.
Has anybody else kept up with some of the other methods they're talking about? Like maybe, the DTC was created under Article 8 for the purpose of an indirect holding system, for the speed of transfer of assets, the securities, because the DTC would hold all the securities, say, in the world, and they would be in one master computer, and they could transfer from one account in that computer to another account at the split second of push of a button. That's why the DTC came about. And it's called the indirect holding system, where we don't actually have ownership of our securities. There's an intermediary who has been appointed for the purpose of ownership temporarily. And we have given them by power of attorney and registered them with them. So I'm thinking we need to go back and unregister those securities at the DTC, get rid of the power of attorney and revoke that, and register these securities in our name, in our trust. And under the Article 8 UCC, if anybody has that handy, in the introduction, under Section C, Section C. Yeah, Section C, it's called, the title of the Section C is Evolution of the Indirect Holding System. Now, I have a 2004 edition, it's an older one, but anyway, it's on my page 790 is where Section C starts, Evolution of Indirect Holding System. And then I skip a couple pages to the end of that section, and it talks about settlement. It says, a settlement is to close and settle. Settlement of market trading in most of the major U.S. securities markets is now effectively primarily through some form of netted clearance and depository system. Virtually all publicly traded corporate equity securities, corporate debt securities, and municipal debt securities are now eligible for deposit in the DTC system. Recently, DTC has implemented a similar depository settlement system for the commercial paper market, or NDIs, and could, but for limitations of present Article 8, handle other forms of short-term money market securities such as bankers' acceptances, accepted for values. For trading in mortgage-backed securities such as Ginnie Mae, a similar depository settlement system has been developed by Participants Trust Company. For trading in U.S. Treasury securities, and get this, and somewhat analogous book entry system is operated under Treasury rules by the Federal Reserve System. The Federal Reserve has a parallel system. Where's the number at in the back of your Social Security card? It's in the Federal Reserve. I think instead of going to the DTC, we need to be going to the Federal Reserve because they have the same capacity as the DTC. Has anybody looked on the Federal Reserve? Because there are some applications there. Has anybody checked out the Federal Reserve site? Press *6 if you want to unmute to speak. I guess nobody knows anything about that then, huh?
Yeah, this is Doug in North Carolina. I've been following the seminar notes, audios, the Unity Conference.
Uh-huh.
And there's stuff on there on how to go through the Federal Reserve Board, Federal Reserve Financial Service website. He was talking about getting that debit card. There's other forms you fill. Besides that, he said there's another method to get funds federally.
Okay. And what website was that again? That you say you were on?
Financial Service, Federal Reserve Financial Service website.
And who again was talking about that? They had some.
That was Tony King.
Okay.
On the September 11th conference. I sent you a little excerpt of what Gene Keating said about trying to claim our trust funds. I sent an email to you.
Yeah, I've read that before, yeah.
We should be able to claim those trusts.
True. We have them unregistered first, get them out of the DTC's name, register them in our name again. Anybody else have a question right now?
Hello?
Yes. You're kind of breaking up. Say again?
Just about the Federal Reserve window. No one got in that way, as far as I know. And I know quite a few people who tried it. Apparently the method was flawed. There were certain forms deliberately left out.
Mm-hmm.
That's what I understand.
Again, I kind of point to the main stumbling block, I think, which is everybody's problem, is that we have a discretionary trust in place, and that's where the trust funds are being held. And it's a discretion of the trustee. He's got the discretion to say, okay, withhold or pay. So I think we really have to knock out that first. We have to pay our fair share of the debt, say. I think that's going to make a difference between night and day, whether or not we're going to have, if you knock that out, if you don't owe anything on the war debt, the reason why this all came about, then those funds should not be at the discretion of the trustee.
So step one would be claiming the Declaration of Independence Trust and making a special deposit of that. Would that be the first thing that we need to do?
I'm thinking that's got to be the first thing, yeah. It's just like when we did all the debtor-creditor stuff, when we put it in with, say, Paulson or Snow or whoever we did it with, the Secretary-Treasurer. And we did the birth certificates, and we deposited them with the Treasury, Secretary-Treasury. But all that was really done under debtor-creditor because there was no expression of any trust there. So that allowed them to construe it any way they want to, for sure. And now with this new finding on the discretionary trust, which really fits in perfect as far as I can see, why we're not getting a remedy. And if we knock that out first, so if we did a similar method, what we did in the Treasury to start out with, except make sure that this time it's a special deposit, forming a trust.
On the private side.
Yeah, on the private side.
That might have been a mistake, too, people writing promissory notes, depositing them on the public side.
Yeah, with Geithner, Snow, and Paulson, yeah. Because the private side is the black seal on the Federal Reserve note, like looking in a mirror. And under the signature, under the seal, under the black seal, is Anna Escobedo Cabral's name, and she's the private side. She's in charge of the mint. She makes the gold. So I think we put that again on the wrong side. Number one, we didn't do a trust. We deposited on the debt side of the Treasury instead of the private side with Cabral. So we should have formed a trust deposit with her.
So I ordered a copy of certified copy of the Declaration of Independence. I was wondering if anybody had got theirs back yet. When you were talking earlier, the life, liberty, and the pursuit of modern view, how they construe it to be happiness. I wonder if anybody's got a certified copy back of the Declaration, what it says in there.
Probably says happiness, but I have heard I don't know how true it is, but it sounds reasonable that they have taken out property and substituted with happiness.
Well, I have a certified copy, and it's a certified copy of something you can't read because the ink's so faded.
Okay, once we get that certified copy, then we need to send it off to the Secretary of State to get a apostille. Would that be correct?
Yeah, we need to make it so it's in the Hague Convention, so it can be seen from an international, since we're being foreign, so that the United States can see that.
We get that all done, and then we'll be working on making a special deposit to the private side of Treasury, special deposit on the private side of the Treasury, which we can later on make non-negotiable lynching calls with that, deposit it on the private side, and have the interest brokered over in the public. It's non-withholding because it's from a foreign source, a private source.
Right.
But now once we start to say we make this special deposit, because what we're really trying to accomplish is to get our status straight with the IRS, because all other files have to report to them.
Right, like I said in that instructions for the requester of forms W-8 Ben and W-8 IMY, where it was talking about the due diligence part, I think it was on page 4. Where if there's any other information that gives them, the intermediary, any kind of doubt as to whether the information you supplied on the W-8 forms, that it wouldn't be true, then he doesn't have to honor the form, which is anybody who's got any records, and the master record would have to be the IRS in the individual master file to correct that first.
So the first thing we need to do is make our special deposit over on the public side, and we can go over to, on the private side, we can go over to the public side and tell the IRS, now, here's my status now, I'm a non-resident alien. When we get to that point where we're going to notify the IRS with our substitute BIN forms just to qualify our status, certify our status, do we need to turn in our driver's license, or do we need to make sure that all that's done away with before we send in these substitute BIN forms to the IRS? Because like you said, they start punching in their computers and find out we got driver's license, you got insurance, you got bank account, you got this, what about the light bill in your name or in the corp that looks like you?
Mm-hmm.
Does all that matters?
Well, these are things we have to weed through on the way through this journey. I know there's been things I've said about that already with different other people that have stated. Was there somebody in the background there that said something?
This is Danny in Texas.
Yeah, go ahead.
It appears to me that we would have to set up this special deposit in a bank, and the bank wash all the transactions. I mean, if we have to pay for renewing a driver's license or registration or whatever, it would go through the bank, and the bank would wash that, the public side, the private side was entered into our special deposit account.
Are you talking about originally the original one that we're going to use is the Treasury on the private side instead of on the debt side. That's where our special deposit will go. Are you talking about another account on a bank and on the public side that's going to take care of all the straw man's debt?
Yeah, like our first bank in our community where we live, to do our business, live, what have you.
To clear up the straw man debt?
Right. In the early 90s, I had a W-8 account, one bank. I got seized by the IRS in 94. I had 3 bank accounts, and they wiped out everything in the bank accounts except the one where I had a W-8 account, and they never touched it.
Oh, they didn't seize the W-8 account, huh?
No.
Was that a W-8 Ben?
It was a substitute form in lieu of W-8 Ben. It's kind of the way I had done it.
Uh-huh.
But it was no Social Security on the account number.
Did you have a certification part like on the Ben?
Yeah, it was something like that.
How'd you get the idea for that? Was there
from the W-8 form.
It said on there you could do a sub at that time?
Form W-8.
How long ago was that?
Early 90s.
The 90s. Okay, 92, say.
Did the straw man have a Social Security number at the time?
Yeah. I had 2 other bank accounts with Social Security number on it, but this one, there was no Social Security number, and the IRS never touched it.
Have you ever seen the account security agreement?
I don't think so.
It's kind of like a UCC form set up about 5 or 6 pages long that actually gives the entity a notification that you've got a claim on the account. And if you put a notice in after that, then the intermediaries or the bank can't do anything other than what you say. And nobody else can seize the account. So it's like,
I did do a UCC1 on the account.
Okay. Possibly the account was leaned up at that time, too.
Right, that's a possibility, too. In some ways, I think I knew more then than I do now, but I don't know.
We should be going the other way.
Yeah, it's gone the other way since.
The more you know you don't know.
Yeah.
Yeah, find out there's so much more to learn. So any other questions we got so far? Anybody else? Dave, are you on the call tonight?
Christian?
Yeah, go ahead.
You were talking about whether to go to the Federal Reserve or whether to go to D.C. DTC is actually DTC, and then there's 3 entities under DTC, which are run...
Well, wait, back up. Yeah, DTC is Depository Trust Company.
Correct.
And then there's DC is the corporation.
Correct, which owns, in essence, my understanding, and I may be wrong, but my understanding is the DTCC is the beginning, and then it goes to DTC and to the other entities.
I think what they were thinking that the DTC was the one that was like sitting on the private side, but has access to the public side, kind of acting as a pass-through.
Well, and then there's another organization that the DC has used that now has their name on all securities, and I named it
Seed and Company.
That's it. On all securities, including all securities that are traded from brokerages.
Right.
And would that trustee not be within that group there before it jumps out to Federal Reserve?
Well, see, the DTC is acting as the trustee, so to speak, or the intermediary, because they've got all these securities registered in their name. Through power of attorney, we've registered all the securities with the DTC for this purpose so that they can hold them and they can have ownership of them, they can transfer them back and forth in the accounts, although they still belong to you as beneficiary. But it's just like they've split the titles. The trustee, the DTC, has got the legal title, but yet you got the beneficiary title. But the trustee is the one that's got legal ownership. So we got to get those back and register them in our names.
Well,
merge the titles on those again, so to speak.
So would not the pulling back the power of attorney on that come back to basically going through the DTC? I'm just curious if you really think the Federal Reserve really gets involved to that point if we don't go above the Federal Reserve to DC.
Well, I think that the asset value is held in the Federal Reserve anyway of everything that's in the DTC.
Isn't that where it's actually transferred in and out, though? Is that not what actually the Federal Reserve is doing for them?
Yep. Yeah, it's like the IRS is keeping track of the records. The DTC is doing the transaction, but yet the actual assets are held in the Federal Reserve, and they all work 3 together: U.S. Treasury, Federal Reserve, DTC, and they're all working together. IRS, the other one I couldn't think of, the other one, IRS, but everybody's got their function. The IRS keeping track of who's got what account. DTC is doing the transactions, but they're all working together.
But the actual creation of the trust holding the power of attorney, you're figuring is DTC or the Federal Reserve?
Well, the DTC, I think, has got where Tony King and the rest of the guys were going in there. I don't think we need to go there. I think we should be going in the Federal Reserve.
Because there was a lady who made a comment about earlier on the call about having to go in and set up an instrument through the C to meet eligibility.
Yeah, see, I don't think we have to really meet any kind of eligibilities in the DTC. We already are in the DTC, so to speak. We already got securities in there. We're already there. Why do I need to come up with some kind of get them to okay what I've already got?
Other than maybe not to okay what you've already got, but to recognize you like to do them with the W-8.
Yeah, I think that would give us the credentials as long as we cleaned up our other records in the IRS. Now we're looking as a foreign entity, not subject to withholding. we basically broke surety between the straw man and the real man. We paid the back war debt. The trustee is no longer functioning as a withholding agent to withhold or per discretion.
Well, what I did is I sent a FOIA request to the Federal Reserve, and if they don't respond within 20 days, then I'm filing a lawsuit in Washington, D.C. to get all the records out of the Federal Reserve, and that should disclose what's there.
There was a woman that did a...
Well, it may not, and that's why they'd be taken into court. If they're holding themselves out as being the government, which they're not, then they should be subject to FOIA. And they are in the FOIA list of people who do accept FOIA. So, I'll see if on the 21st day, if they haven't responded, I'll file a lawsuit.
Their actions.
They hold themselves out as being part of the government.
Like the IRS.
IRS.
Right.
The IRS will tell you they don't fall on FOIA request if they'll answer.
Welcome to Oz.
Yeah, right on.
There was a woman that did a request through a broker, and that broker punched up the assets on the screen. Is anybody familiar with that information?
I've done a CUSIP search on my birth certificate and my court case, and what you end up with is you end up with a mutual fund number, and the only way that I think that you can identify your particular asset in the fund number is to either depose the fund manager or audit the fund itself. And I think that's the only way you're going to find it, because they hide them very well in those funds.
I believe this was Patrick that talked something about that. The lady was on vacation and she was coming back. She was going to do something else. I forget what it was. Yeah, who was this?
I got a question.
Is this Mike?
Yes. My late dad has a check account at the local bank, and I'm going to go over that check account, and that was the 8 Ben. Is there any suggestion you got that I was going to open my own check account without associated?
Yeah, well, the 8 Ben would be the way to approach it, or for you to open up an account there without a Social Security number.
Right. And then what about, on taking my dad's old check account? One of the things saying is they can my name or card, and I was going to make it W-8 off.
Has it got a Social Security number on it already?
It does.
Yeah.
What do you just do, start step one in this matter?
To claim that account, or?
Yeah, just let's just say step one is claiming without worrying about it.
To claim it, so not to worry about anything.
Yeah, in other words, like, say, Social Security's asked Dave something, he had Medicare. They have been known to come back and reassess things and try to get the money from people.
So you think maybe he owed something and they might come back and try to get something from you then?
We know that has happened in the past, the last couple of, when you got Medicare, and particularly so stated, Dad didn't have that, but he had Medicare, and what they come back and say that since he's in the hospital to go, he owes $1,000, blah, blah.
Well, if they ever did come at you with a bill, you could always, handle the bill as a trust deposit. So I wouldn't worry about until something really happened.
Okay, all right.
But now the question is whether I want to take over that account, having it already have a Social Security number. That's the question. I don't know if I'd like to do that or not myself. I might just try to go after a brand new account without a Social Security number. And as long as they don't have any other conflicting information, you might be able to get that, just in your own name without a Social Security number. Or is there any particular reason why you wanted to use that account?
No, I was going to put it like legacy. They'll pay bills if I'm at his house, going like that, the legacy kind of thing.
Well, why don't you try a dual then? Get one without a Social Security for yourself, and then try this account to get it under your belt, so to speak, if you wanted to keep it as a legacy.
That was kind of my plans like that, to check it there.
That way you're really not commingling any funds that way, too.
Yep, and Dad, under Social Security, just looks like a joint owner.
Yeah, that way if anything did happen, you wouldn't be tied in with it. Then you'd be, you hadn't mixed in any funds and stuff.
There you go. That's kind of what I was asking, kind of something like that. And I was wanting the OID check account the last.
The problem is where we've been commingling the funds without us really knowing what we were doing. And like I talked on that Monday night call.
What do you think about OID things and step aside from it? We do it right now and we get out of it.
Yeah, that's what I see as the problem. and then try to get everybody educated as to what really commingling is, because you're taking the source of the funds being on the private side and you're commingling them on the public side, mixing oil and water. And we wonder why our set-offs don't work, and, that's one of the major problems I think we're doing wrong. We're not keeping private things private, public things public.
This world is rigged with commerce that takes corporations.
Yeah, but just like Harold pointed out, I thought about that before, it's the same way.
Right.
Commerce is really nothing because it's fiction.
Right, but everything in corporate name, utility.
All the colorable titles.
Everything titled.
But I think we just haven't gained enough experience and knowledge on how to manipulate both sides simultaneously.
Well, it seems like the safe way is you had trust that all this set, and it would operate out of that.
It is a trust. Everything is a trust. That's just what we must look at it as, because that's what it is. Everything is a trust.
Yes, sir. See how it connected us for that corporate name.
Right. And all I got to do is break the suretyship. And I think that W.8 Ben is going to be the form that will, once we get the individual master file all taken care of.
I mean, we're right on break of getting remedy.
Yeah, I think the key is pay the fair share of the war debt. It's like we got to go back to the start. What caused all this? Where does that first root come out of the ground? That's the one we got to go for. Just like Rhonda says, cut the head of the snake off.
Do you think that would be done by the IRS?
Who's going to make the payment? Who's going to make a payment to them? The IRS was the one who's got the bookkeeping, but the funds are probably still held in the Federal Reserve or in the Treasury. So the assets have to be there. Now, if they've taken the gold and moved the gold off someplace, there still has to be IOUs in there. But then if they produce the IOUs and come up with certificates of gold deposits, really that would be a proof that the funds were commingled. And that would be a breach of trust and breach of fiduciary duty right there. Because if I made a special deposit back in 1933 with in-kind in, I should get in-kind back out. And if they're going to give me a certificate, I put gold in.
Yeah, we're holding certificates of something.
Yeah, and all the certificates are just colorable titles representing the real thing.
Right.
Well, if I put the real thing in trust, then give me the real thing back out of trust.
Yeah, but like you said earlier, did we express that?
No, we never did. That's our problem.
But we can come back and express it now.
Yeah, we can always come back and fix what we messed up. We're the grantors on the whole thing. Modify that back to where that's being construed, get it back to where it was my original intent. Then when I put that on, then I can do the commerce through the trust by putting the face mask on as some kind of fictional entity, say to interface into public, so I could get a hold of the colorable titles that gives me access to the real property for the goods and services I'm going to use to support the real man held in the private. I keep coming back to this legal fiction definition of Black's Law, where it says on 8th edition, it says in the fine print section under legal fiction, it says, legal fiction is the mask that progress must wear to pass the faithful but bleary-eyed watchers of her ancient legal treasures. So our ancient legal treasure, that's the unalienable rights given to us by God. But the straw man is the mask that progress must wear to pass the faithful but bleary-eyed watchers. So we got to use the straw man or a straw man entity as a mask to interface in.
Where was you reading that from?
Black's Law, 8th edition, definition of legal fiction.
Legal fiction.
It's designed to work public and private both simultaneously, and instead of us trying to get out of the public realm, we need to learn how to interface with it. Who was speaking there in the background? Go ahead.
Yeah, it's Kenny here. I had a question. If I could digress back to the W.8 Ben conversation we're having.
Yeah, go ahead.
Is that possible? Well, first of all, I'd like to ask of all the listeners who are on now, has anyone in this group succeeded in opening up a bank account with W.8 Ben whenever they, in fact, do have a Social Security number? And if so, how was that accomplished? I've tried it twice. It was unsuccessful both attempts.
With a W.8 Ben?
Yeah. Well, what I had heard that Wells Fargo, you could do it there. But what I ran up against is that inherent in their system is a bunch of questioning, which involves where was born, are you a citizen of, and the road I went down was, I'm a Texas national. Where were you born? They keep questioning, and their system, there's you were born in a particular state, that didn't show up in their list.
Right.
And absent a foreign passport, which if you have a foreign passport, do it. If you have dual passports, I think you can get away with it and walk in and say, here, I've got a Swiss passport. Here's a W-8 bin. I want to open up an account. And you can do it then. But those of us who don't have dual passports, who in fact do have Social Security numbers, and were born in one of the 50 states, I'm interested to know how it's done. I've talked to people that claim they've done it, but I've never been able to figure out exactly how they've done it. So if anyone here has done it, and has success in opening up an account without a social, without giving a social, and using a W-8 bin without giving a foreign passport, I'd like to know. Please pipe up and tell us what you did, right? That was the first question.
Well, this is Danny in Texas. I stated earlier that I opened an account in the early 90s with Form W-8, which is non-resident alien, and I did it without a Social Security number. And the IRS seized on me in 94. I had 2 other accounts. They got everything in 2 other accounts, but they did not touch that was W-8 account.
Right. We all got that. So maybe you could expound a little bit more about how you actually opened that account up. Now, let me first ask, at the time you did this, did you in fact have a Social Security number?
I sure did.
You did? Okay. So tell us what it is you did to get the bank to allow you to open that up with a W-8 bin.
Actually, it was not a W-8 bin. It formed in form of a W-8.
Oh, yes. Okay. I remember you said that. Okay.
W-8. I didn't actually use their form. But again, I think it depends on the bank, if they want to let you have an account like that or not. And now, today, I tried just a few months back to open up one, and if the guy at the bank, the head guy at the bank, wouldn't even talk to me, other than,
right.
Oh, we're not talking about it. That was it.
Yeah. I think since 9/11, there's been a lot of what happened with the Patriot Act financial regulations, and they certainly have tightened it up. Is there anyone listening here who's done it since 9/11 and has had success doing it? We talked about earlier. I'm gonna take that as no.
It is fairly not, yeah.
Yeah, it's that's a thing that's very difficult to get around. Okay, well that leads me up to the next question. I was going to kind of see if you could explain maybe a scenario. I've been studying the book, but still having a little trouble wrapping my head around some of the concepts. Let's just use an example here. Let's use the example of an automobile in which probably most everyone on this call knows that you don't really have legal title to the automobile. You have equitable owner-operator title and status to an automobile whenever it's registered with the state. How would you define or how would you explain that relationship? Would that be a trust relationship or would that be a Baylor-Bailey relationship?
Well, you'd have to ask the question out of the book there, which really started on page 6 where we talks about the relationships. Trust were distinguished from similar relationships, where it says the characteristics, not terminology, is controlling. So similar arrays of rights, of responsibilities, including fiduciary duties, obligations, may be found in a variety of other relationships that are in varying degrees somewhat similar to trust, but which lack one or more of the essential characteristics of a trust. It's often difficult to ascertain whether the parties involved intended to create a relationship that was recognized in the law as a trust, because the use or the failure to use terminology is not conclusive of the party's intent. So you really have to go back to this, starting on page 6 here, on talking about the relationships, because it talks about bailment next, and the guide for distinguishing whether it's bailment and the differences between bailment and trust.
Well, in the case of automobiles, it would seem to me that it might be a bailment situation because the state is holding the actual title and allowing you as the user to have an equitable title.
True, but who's the one who set it all into motion? Who was the first signer on the whole thing?
Well, of course, that was the person who made the purchase at the dealership of the automobile.
Right, so that person, that party would be the grantor of the whole thing.
Right.
Now remember, when I handed you my pen, I didn't know, you didn't know that there was a trust form.
Right.
So now, your actions, what you did, determined your intent. So by you not expressing the trust, you're demonstrating your intent that you didn't intend to form a trust because you never expressed it. So now come back in and re-express it being a trust, and then make sure you have your 4 elements, your intent, purpose, parties, and specific res, the 4 elements.
So, and that relates to what you were talking about early on the call.
Yeah, right.
If you, the 2 entities you talked about, so if you as grantor trustee didn't express your intent whenever you signed the title over to the state, then it appears that you gifted the car to state.
Yes.
What you're saying is
under debtor credit or some other kind of relationship.
Okay.
Could be bail. They're construing it as bailment, maybe. Or maybe they're construing it under debtor credit or whatever it is. There's some other relationship, but it's not a trust. Because all those other relationships lack one or more of the elements of a trust. There's one piece missing. And the piece is you never expressed the trust and made sure that you had all the elements necessary to call it a trust, that the law would recognize that as a trust. And one of the methods of formation, whether it be declaration or transfer or appointment or contract. If we would have done that, or come back in and correct the problem.
Right, okay. One more question and I'll defer to someone else. Also on page 8, when you talk about remedies at section 34, and I've heard these terms many times, but I'm not sure I'm really understanding them. Maybe you could clarify. It talks about the rights between a bailior and a bailee are usually enforced at law, although if unique chattels are involved, equitable relief may be appropriate and available. These duties of a trustee, the duties of a trustee are enforced in equity. What's the actual real difference between something enforced at law and enforced at equity?
Well, equity is on the private side of the court, and at law is on the public side of the court. So your trust is operating in equity, and that's the representation of the substantive rights or the real substance of the real man, and that's in chambers.
Oh, okay.
So that's where we've been putting all our information on the wrong side of the court. When we come in with all these administrative remedies, the private-sided administrative remedies, and we shove them in on the public side of the court, and they're on the wrong side. You put them on the law side instead of the equity side, you can get a remedy there.
So, back to the automotive title example, if someone came back and expressed that there was a trust rather than a bailment situation, they might actually be able to express that trust and then gain the actual legal title rather than just the equitable title.
Okay, that was coming back to the 3 examples I was putting forth, because now it comes back to your intent. What was your intent? Was it intended to be a gift that you gave it to them as beneficiaries under construment? Or were you making a special deposit that you wanted it back?
Well, given what I know now, and looking at true intent, I mean, I don't know that anyone ever purchasing the car to give it to state. They just didn't know what they were doing.
Yeah, well, the trouble is that they knew it was a trust, say, and you didn't.
Right.
So now it comes back to what I was trying to demonstrate was, what was your intent? Was your intent to gift it to them, or was it your intent to bring it back out as a special deposit in kind back in and get the same thing back out? Because all the same parties are there. Nothing has really changed. Only the positions in a label situation just flipped from the label on the trustee, went to the grantor side, if you think about it. Because in one scenario, the grantor is the beneficiary, one and the same. And in the other scenario, the grantor and the trustee are one and the same. And in the third example, the grantor is all by himself.
In your opinion, would there ever be some statute of limitation on how much time could pass before someone could come back and restate what their intent?
I don't think so, because you always have an omission, because it would be a fraud because they didn't give you disclosure.
Right.
Under mistaken fraud.
So that fraud would vitiate it all the way back to the beginning, whenever it started. And since operating,
they commingle funds, right?
Yeah, that's why they don't produce the notes, because if they produce the signatures and stuff on there that they've been modified, now that's a proof of commingling. And if you express a trust, now you got them in a breach of trust. Like I talked about on the show on Saturday, you can come back in now with antitrust, because they're operating against your trust and they're impeding commerce. The banks have a monopoly on an unfair advantage, because they have a high skill and you don't. They write the contracts and you don't. So there's antitrust right here we can bring in there, and the criminality on top of that.
Well, I guess one could venture to say that opening a bank account is a similar situation, in that you've not been given full disclosure. So
the deposit you've made actually becomes a gift to the bank rather than something that now they offer you the privilege or whatever of actually getting credits back out and being able to come back in later. But, folks like Winston have said many times that you go and set up a bank account, put whatever in there. I hate to use the word money, but when you put some form of sweat equity in there, you're actually gifting it to them. And
under debt or creditor, yeah, you would be. Under construment, to be construed under debt or creditor, yeah, you'd be giving it to them.
So you've once again, it's a gifting that you didn't realize you were doing rather than a transfer. Yeah. Okay. Well, I'll mute out and let somebody else.
Yeah, because if you think the same way as what I'm giving you the pen, if that was a bank, I was giving them the asset. But here all along, none of us knew there was a trust, except the bank knew, though. They knew what they were doing. Maybe not the guy that you were doing business with at the bank, but the banks were set up knowing what was going on. Let's put it that way. The guy that I did the deal with, that I traded papers with, he probably didn't know anything about it. He thinks he's doing the right thing. But along the same scenario, I could call that a special deposit. I just need to set the trust up.
These things would be expressed on your notice of interest, statement of interest, and to go back and express trust and to prove trust.
Yes, right.
Start to go back to claims, starting with the Declaration of Independence, or an expression of that, a notice of that, and an expression of that, and a claim on that, and then right down the line.
Yeah, because once I make a claim, I got to prove the claim, or if I make a claim as a trust, I got to prove the trust.
So probably once we learn how to do the notice of interest and a statement of interest, probably what we'll be sending in something like that along with the special deposit private side of the treasury. Once we learn how to write those, we'll have a pretty good idea of how to write NOIs and SOIs on future things.
Yeah, the SOI is nothing more than a material fact to prove your claim, which is the NOI. So if you have to have it, just like the Bible says, you have to have two or more witnesses to establish a fact. So I need two or more witnesses, and those witnesses are records or records of evidence. And those are the UCC ones and the county recorder to prove the claiming and the moving of the title. So actually the model is simple, because it's scriptural really. So the moving title platform. And then we're just going to, which is really basic government, really, because that's due process. Because you're going to, set up evidence. You're going to notify parties. You're going to notify all the parties that are in interest there. And then you want a hearing. You want an opportunity to be heard to where the other party can rebut your evidence. And if they can't, then you win. Since they're operating fiction anyway, are they going to prove any of this stuff? But where they get us is they get us so that we don't put in evidence in the right place in chambers. We never get any evidence in the evidence file, and they've got prima facie evidence by some affidavit and some copies, and they end up winning just with that, because we don't know how to get evidence in to rebut it. But just like what that fellow was talking about, the examples really, what kind of relationships are we forming? And I think if everybody would just run through their minds and look at these diagrams a little bit and play it around in your own mind and actually thinking about, hey, what happens when I give somebody my pen? If I want it back or if I don't want it back. And then draw the little lines and see how the little scenarios work in the different three examples, because that's what's going on. It's got to be a trust. There's no money. It has to be a trust. So we better start learning how to equate things that we're doing in life with a trust.
Would there be a host of parties that we would notify when we do our first special deposit, or would just the private side of the treasury be the only one at the beginning with the declaration as a special deposit, or who would you envision would be parties that would be included, have to be included in the notification?
Well, at one time I had a big long list of about 23 organizations or entities that I was going to notify of all my stuff that I did under the debtor creditor stuff, and I might want to do that again. But it all starts with, I think, the IRS individual master file. Because the attorneys, U.S. Attorneys Manual, USAM, under 6-4.010 states basically that all other agencies must comport to the IRS. Whatever is in the record that the IRS has set up, all other agencies must match it. And then we're the ones who set the records up with the IRS. So we're the only ones who put any information in there or didn't rebut anything that was in there that we should have. And that's the one we need to correct first because all other agencies comport to that one.
Okay, but it's kind of a catch-22 because all other agencies have to comport to the IRS. What they have is your status.
Yes.
However, when you first put into the IRS fix your status, to fix the records that they have, they're going to go back and look to see if you're business in the United States.
True.
And so it's kind of a catch-22. You can't notify
the
ones down here.
That's where you got to stop.
Get rid of all that corporate ID and attachments until you notify the IRS, until you fix that status. But you can't fix that status till you get rid of all your corporate status.
Yeah, it's kind of like when do you jump off the treadmill? Whenever it starts slowing down, when does it slow down enough I'm going to be able to jump off? It seems like it keeps on getting faster and faster. It's just like you got to do it cold turkey.
So you're going to do everything at one time?
I would think about as much as I can get it all done all at once, and slam it all in there.
So at the same time, you send your ID back to state and cancel your insurance, cancel your bank account.
I'm going to disconnect the signatures from those IDs. Those IDs still belong to, say, the account, which is the straw man. But now I'm just going to be the authorized representative on it if I have to be. Because remember,
as long as you can prove you have a qualified signature. Then the private, aren't doing. That's not your business over there in the.
You're not liable for it. You're not liable personally for it.
So they can't attach that to you when you go to the IRS. And say, for instance, on my driver's license, I signed it. I just got one this last year on the corporate driver's license, and I signed it by and the name. So that's a loophole for me to say I'm not doing business over in the U.S. because that's not me.
Right.
That ID's not me. That would be okay.
Yep. We got to watch how we sign. An unrestricted signature makes us personally liable.
Okay. So
as long as we by grantor or by trustee or by beneficiary or by authorized representative on a trust term, then we're okay.
Then that separates. So when the IRS does their little, when I got insurance on for the corporate straw man, I signed the application by. So then I send my substitute BIN forms to the IRS, say change my status, I'm non-resident alien, and they type into their computer and say, oh, Rhonda Walker's got insurance. They're not looking at the application where it says buy. So would that cause a snag, or would I possibly put that in my notification to them? You might find these things, however, if you go back and check the application, they were, had qualified signatures on them.
Yeah, no, I'm going to have to take in each scenario as it comes in and somehow correct it and bring it back to comporting to the IRS master file.
Would the IRS let you know if you did a substitute BIN form, if they found something conflicting out there, would they let you know that? Or I
don't think so. I think you have to look in there and find out, yourself.
So if things wasn't going the way they should be, then that would let you know that they're seeing something they shouldn't be seeing.
Once you did an effective date and cutoff date, then everything that comes around, from that date is going to be history. So as long as you don't, from that date on, incorporate yourself back into it by giving an unrestricted signature, an unqualified signature, and pay particular attention, the relationships you're getting into and how you're signing, then as long as you're not setting up evidence that's contrary to what your BINs are saying.
But the things you already have out there, say the driver's license that I already have, that does have a qualified
but when did you sign them? What was the date on those? And as long as you don't renew them under the same signature.
Oh, okay. So anything after you put the substitute form in definitely has to qualify.
Right. You have to be extremely careful, otherwise you're going to be commingling and get yourself right back in again.
That would be one of those, probably from here on out, it would be a good practice. Anytime anybody wants us to fill out an application is take the original, sign it as grantor, and give them back a copy.
Yes, give them back. Keep the original, yeah.
So we can prove that we're in a trust relationship here, and I'm still a non-resident alien, and that would qualify signature I put on that application.
Yeah, I think you got it. Getting our heads wrapped around. I think we got our problems is we got to unlearn everything we've learned. That makes it twice as hard. Yeah, that's the charge that you're giving the piece of paper, the fiction, bringing it to life. You're the one imparting the evidence, the energy into it, and giving it life. You're the one that's feeding it.
Yeah, I get the whole qualified signature and everything. My concern was because I have a qualified signature on the license that I have now, But my concern was that if I send in a substitute BIN form to the IRS and they go punch in their computer and it just pulls up that there's a driver's license in a name that's like mine, they're not seeing the license, or they're not seeing the application where it does have a qualified signature, and they might say, okay, well now we did our due diligence, seeing that this here's showing that you're acting different than you're saying on your substitute form, so therefore we're not going to grant it. How are they going to know that I already have a qualified signature on the driver's license, or that I have a qualified signature on the application for the insurance?
Well, you would have the proofs because you're keeping the originals, or at least have certified copies, so they got some kind of evidence that you did.
So it'd probably be good to send copies of those applications that show that grantor status or that qualified signature status, maybe along with the BIN form, so that if they do pull up on the computer, they got the papers right there that show those were signed by a non-resident alien, as a non-resident alien.
Yeah, as long as you got the evidence and that you could prove that. I think it gives an example there. I think it's in the 515 publication where it gives a little more in-depth, where you have to make a correction in writing. Talks about.
You mean if you didn't qualify your signature the first time?
Yeah, without me digging information up, it's if there was a discrepancy, you have to make a qualification in writing. In other words, you have to correct the problem in writing.
But if you already did a qualified signature on the original, and you had the original, and you could.
As long as you prove the date, as long as you can prove the dates. If your past signatures were unqualified, and then you pulled out, and then that specific date, anything forward from that date, as long as it doesn't show up that you don't have a qualifier on it.
Date.
Yeah. So as long as you got the dates to prove the dates, from that point on, you've disconnected yourself from the system.
So probably another big thing is you wouldn't want to be using that Social Security number.
Yeah, that Social Security number is not mine.
Right.
Yep.
Mm-hmm. But another guard put a notice to all.
Well, a DIB hearing, 25-06, Treasury Directive. Treasury/IRS Directive 25-06. Yeah, let's say the state of Ohio's records do not comport with the IRS records/Treasury. I call a directive hearing under 25-06 to correct those records.
Question to you guys here: what would it be safe to say that? Excuse me, would it be safe to say that the straw man could never be a non-resident alien, and the flesh being is the non-resident alien and always has been?
You're 100% correct.
Okay.
Now, this is Danny again. Something else I did with the IRS a couple of years back. So I requested FOIA for any evidence they had that I was federally privileged worker or employee, and they answered back that nothing in their records reflected that I was.
What were you saying, Harold?
Seems like you were going to respond to the non-resident alien statement.
The problem was we violate with a
right.
Well, for government pledged himself.
Yeah, I never made a special deposit. Anybody else have a question? Comment? Go ahead. I was trying to make it a little bit later so that people on the West Coast, because it seems like we have a lot more West Coast people on here. They're about 3 hours behind us, or 3 hours ahead of us, whichever way it is. Last time we went a little long. I was going to try to hold it for about 2 hours. So, and this call will be more of a Q&A period. So, anybody else have a comment or a question?
Christian?
Yeah.
Yeah. I'm just looking at Liechtenstein secret banking. You know, Liechtenstein's quite famous for its banking laws.
Right. Mm-hmm.
I'm just reading an article here where it's saying that Liechtenstein claims that it helped a lot of the German Jews from the Holocaust. I'm just wondering, can we find more information about back office banking from Liechtenstein banking sources?
Yeah, but a lot of the stuff is probably more on the public side. You almost got to have a personal relationship with a bank, almost having to know enough certain amount of information to get in the bank so that they know that you're online, so to speak, or on par, so that they'll start talking to you.
Well, in Liechtenstein, it's pretty much standard to have secret banking banking, or has been up until recently when they had the crackdown.
Yeah, I think that the foreign banks outside the U.S. are probably going to be more receptive to what we got going on.
Yeah, I'm going to continue to look down that avenue anyway.
And then, like we were talking about on the SDRs, the special drawing rights, in relationship to, say, the trades, and setting up the special deposits and generating the interest on the public side.
So would you think that Liechtenstein and maybe Switzerland do operate solely in the private capacity?
I think all the banks have a private side. They all have a back office banking system connected through the TTL accounts. It's just what party's the guy that's going to open the door for you so you can walk in.
Yeah, no way. Liechtenstein. So it seems like a lot of the pressure's being from tax agencies because of the non-payment of tax.
Well, I think what they're doing is they're drying up the currency and making currency scarce. Currency's there; it's all locked up in treasuries. All they got to do is turn the spigot the other way and let it run out again. They're controlling things into a bust situation. Yep. But they're only controlling on the public side.
They're effective money, because keep in mind, there's no accommodation. So therefore, time through math alone, it has to that they're doing this on purpose. Because I'm in real estate just throughout, people can't, the bank.
They don't have any credit.
If there wasn't a, it was actually off.
I'm wondering, through looking here, because it says that the former UBS private banker, Bradley Birkenfeld, has agreed to a plea deal and is reported to be cooperating with the U.S. authorities in bringing charges against American citizens on tax evasion charges. I'm just thinking that it'll be interesting to see how them American citizens go about their own cases. Because we are studying commercial redemption, and that would be the perfect remedy for them to separate from citizenship, because that's what the authorities are acting upon.
The citizenship, yeah.
I wonder if it would be possible to get in touch with any one of these. It says there's a Washington lawyer called Jack Blum, so they're obviously getting represented by lawyers. It says Khyber should be considered a whistleblower and a hero, not a thief, for revealing how the super rich hid billions of dollars using the Liechtenstein bank.
So what are they doing? They're bringing up individual charges against U.S. citizens?
Yeah.
And they're saying that they were for tax evasion?
Yeah.
In their country?
In Liechtenstein, yeah. It says tax.
Say again?
The reason they're doing that is they're trying to break, with the Terrorist Act, they're trying to break the bank privacies. They've already done it over in Switzerland, and they're going after the other countries. And then what they're doing is they're putting pressure on those countries that if they don't give up those citizens, that they'll close all of their domestic banks here in the United States.
So it's all about control and everything. Yeah.
It is. There's so much money going out of the United States. If you look at the dollar value that leaves the United States every year, it's tremendous, and even more tremendous now. People are moving out of the United States as well. So what they've been doing is they first started under the Terror Act flag that it was terrorism, that you were letting terrorists launder money by not giving the United States the records, and they've already opened up a couple of banks that way, and it's caused the Bank of Switzerland a lot of problems. Actually, so now Liechtenstein is one of the havens for people to open up trust and protect their assets. And so what they're doing is they're doing the same thing with them. But what they do is they charge them that any business that they have in the United States, they will absolutely seize it and shut it down. And so that's how they're pushing that button. And they got away with it one time. And for them to get into Liechtenstein is a whole other game, because that's like the capital of privacy.
Well, maybe we should take our PayPal accounts and switch them all into different kinds of currencies, but U.S.
That, or put it into some sort of metal.
It says here that I'm looking at the Dresdner Bank Monaco. All bank employees in the Principality of Monaco are required to observe strict banking secrecy, which is protected by the provisions of Article 308 of the Criminal Code, as well as by the Professional Code of Conduct. Included here are the protection of customers' privacy, information concerning the customer's financial details, and also business and private data. All information relating to transactions, investments, and bank account details are treated as strictly confidential. Matters involving criminal offences are excluded from the protection of banking secrecy in Monaco, just as they are in all other well-reputed banking centres. Furthermore, special regulations apply in the case of French citizens. So it seems like Monaco could be the place.
Well, hopefully that would be true, but the thing is they say that, but they also said that at the big Swiss bank, UBS, I believe it was, that they shut down. And what happened is UBS tried to give all of their clients, their American clients, to other banks in Switzerland, and the other banks said, "Oh no, they'll track them to us, and then they'll come after us. We don't want to take them." And so, who was it? One of the Beatles singers, what's his name? Paul McCartney. Yeah, Paul McCartney got hit really hard when they did that, actually. And but that they use it, as you say, it's a control thing. They're wanting to control this, and they don't want anybody to have any hidden secrets. But if you're looking at a worldly power also, if you're looking at people who are trying to control the world, they're going to want to control all the banking. And if they've already gone in to all these banks with these derivatives and have taken the world off of this bad debt scenario that they've been trading, and they're trying to trade it again, they are going to try to go into the banks. And they're going to go into the banks which harbor the majority of the wealthiest people's accounts out there. Well, there are a group, a large group. As big as the group is who's doing this, there's a group that's not, that's fighting this. And they're fighting on our frontier for not only us in this country, but also for the world. Because when they reached out this time, they reached way out. And they disrupted a lot of people. And it may not be as bad as we all speculate it to be, but that does not mean that we shouldn't get our sovereignty either.
Well, I've heard there have been several arrests, and they've frozen the accounts, and that's why you're not getting any money, and that's why there's no movement right now. And it'll start coming out in the next couple of weeks who's been arrested. And there are some pretty high-level people that we all know and maybe don't like.
Well, and being the case, if all that comes to fruition, as we hope it will, the Constitution will be put back in play the way it's supposed to be put back in play. I mean, it's the guidelines for which the country's supposed to be run by. That will happen. But, we never really hear about what the good guys are doing out there. And there's a lot of them. And there's a lot of very powerful people that you never hear about that are out there, and they've been fighting this because they don't want to see this happen to their own countries, much less to this country, because this country has a lot to offer to other countries. And now also what's happened is that people in higher places who normally could not speak out due to the fact of the Internet, which has been a tremendous instrument for them, have been able to get information out and can communicate without getting themselves compromised in their position. And they're seeing what's going on, and they don't like it either. So we don't get to hear about that kind of stuff very often, unfortunately.
Well, I can tell you that I'm the treasurer for the Mountain Division of the Republic, and we are very, very close to actually getting enough counties to assemble in the Republican form of government so that we can stand up and establish the civilian government back to where it was. But it's a hard job, and we do have a bank.
I heard you did.
Yeah.
I heard you did. That's great. I think that's wonderful. I heard that last week, I think.
Yeah. I'll be helping setting that bank up.
How can we get an account there?
Well, it's membership. They're going to do it as a membership to start with to try and just stabilize the economy. It's a big mess. I mean, what's going on in Washington, D.C. is a big, big mess. The Chinese have flown in with Interpol, and they've been arresting people. So, I'm only disappointed that we didn't do it because I think that we knew they were criminals. We knew what they were doing, and we should have taken back our own country and cleaned our own house. But the Chinese came in and did it, and I don't know what's going to result of that. I have been told that the man who has a substantial amount of money does not want this country to fail, and that's probably why you've seen a little bit of lift in the dollar. We do have to stand up as a republic, and we do have to, establish our civilian form of government because we've been under military rule for, since the Civil War, and none of us knew it. We thought that's the way it was supposed to be, but that's not the way it's supposed to be. And we've had to go through a very extensive learning process to find out what the Republic was like. Because, I don't know about you, I'm an older lady, but I don't remember it. I remember, just after the Second World War, but, we were under military rule at that time. We don't want military in the streets. Not ours, not theirs, not anybody's. So we have to stand up as a civilian form of government and say, we're here to run our country.
Yeah, read through the Handbook of International Banking yesterday, and it expresses America as being a debtor nation. And I was just wondering if anyone can throw any light on that description of America.
I'm sorry, you said a debtor nation?
Yeah.
Well, we have debt. We've never paid the debt. We never paid the debt from establishing this country to begin with. And I don't know about anybody else, but, it took me a while to figure out that a Federal Reserve note wasn't money and what had actually happened in the 30s, because, I was born after that. My dad didn't know. He was born in 22. And he had no clue. He thought bankruptcy was the normal way you did business, I guess. But, he went through it 4 or 5 times.
Sure.
And,
I think it actually goes back to 1911, doesn't it, with the Federal Reserve Act? That was the first move towards the 1933 Act.
Well, we've had a central bank in and out of this country for some time. There have been periods where we haven't had a central bank, but this central bank that we have now is very corrupt. There's enough money that's been stolen from our trust accounts that pay off the national debt, and actually that's probably what's going to happen is we're going to end up without a debt. And some of the people that are very high profile in the government have been arrested because they have stolen the money. And, I'm all for it. I don't want criminals in my government, and, they're very corrupt. It's getting solved. That's all I know. I'm just sad that, the American people weren't the ones that stood up and, took care of this problem.
Well, I think it's a quite severe attack, so it's no disrespect to the American people.
Well, I'm not saying that out of disrespect. I'm saying that, we need to clean our own house.
Yeah.
How many mornings did we have to have? I mean, Ross Perot's going around, it's time to clean out the barn, take out the trash. Nobody did anything. They were too busy in, Viagra and Botox, we need something more substantial in our country.
Welcome to America.
Yeah, welcome to America, right. But, we forgot about freedom and, started thinking about other things and, we got lots of things to do. We have local governments we have to clean out. The states are too big; they're running too big of a government. We have to have our county assemblies back, where we in the county give the state orders instead of it coming the other way. They don't understand who the power is.
But do not live in the county.
I'm sorry?
Do not the people live in the county?
Do not people live in the county? Well, there are 3,600 counties in the United States. Yeah, they live in the county.
What I'm saying, we all live in the county. That's where it needs to start.
Yes, that's right. That's why we're doing the county assemblies. That's why we're standing up. We're staffing up. We're getting our rangers who have more power than the sheriffs. They interface with the sheriffs. We're getting our own judges. We're setting up our own citizens' grand juries because that whole system is so corrupted. It's even funny, the judicial system. The grand jury's become a tool of the state. Well, it was never meant to be a tool of the state. It's supposed to be, your friends and your buddies. They were the ones that knew whether or not you were crazy and needed help or, if you really were a criminal. They understood who you were and what you were doing. So we have to have scribes, we have to have treasurers, we have to have, there's about 8 posts. But, you just go to the county assembly and register, volunteer for a position so we can stand up as a civilian government. And then there's a good chance we won't have military in our street. I'm not looking forward to that. If you want your government to stand up, take it back. Do it peacefully, nonviolently.
Yeah, it only takes it for a few good men to do nothing for tyranny to abound.
Oh, and it's just gone wild. It's gone rampant. What they're doing is just absolutely outrageous. This whole thing with this guy that had a bomb in his underwear or something, that was a whole staged thing.
False flag.
all slag, make us all scared. Yeah. Now we gotta, now we gotta go naked on the plane. We can't get on there with anything now. It's ridiculous.
Girl, you got some personality. I gotta give you that.
I've been around the bend a time or two, but.
Well, I don't mean to take you off the part where you're at, but I do have a question if anybody out there knows this, because I've been trying to find this out. Does anybody know what the UCC statement on the bottom of your bank deposit slip means?
I never use it. On the bottom of a deposit slip?
There is a statement on the bottom. It's either on the very bottom of your deposit, of every bank deposit slip, or it's on the very left of the deposit slip in very light color, usually in its small print.
Well, I use Chase Bank, and now they have just a machine that takes your check in there. You don't have to use a deposit slip or anything. You use your card, and it even gives you a picture on your receipt of the check. So.
Well, there's a statement about the UCC and about collection items.
What does it say?
Excuse me?
What does it say?
I don't have it verbatim in front of me, but it does discuss in reference unto the Uniform Commercial Code in collection items, in items or non-current deposits. And I believe that I'm leaning toward that may have to do with the utilization of an account in settlement of debt as utilizing your coupon.
Okay, I have a deposit slip that says, checks and other items are received for deposit subject to the provisions of the Uniform Commercial Code or any applicable collection agreement.
There it is, collection agreement.
I'm looking at one that says the same thing.
Anybody have any experience with that?
Yeah, it's all about the agreements because the total UCC code becomes nullified by agreement.
It has to do with your signature card, I'm sure.
Christian, would you mind elaborating a little bit further on that, please?
Well, it's like the UCC is like the guidelines, but then if you get a private agreement between you and the bank to do whatever you're going to do, then that's the law. The UCC doesn't take place.
Okay, and if we go into these banks to set up private accounts on the private side, would that not be the same thing?
Yes, right.
So therefore,
if you reach UCC, it comes back to you after a while, unless otherwise by agreement. Unless otherwise by agreement. And it usually starts right at the beginning. Reads that, time and time and time again. And then pretty soon it hits you, unless otherwise by agreement. Well, that's what's really saying, that's what's really making it work. The UCC doesn't mean anything. It's the otherwise by agreement. That's what counts.
It's silent contract.
Uh-huh.
So it's a private agreement with the bankers themselves.
Right.
Thank you.
Well, everyone, study those little 3 examples that I gave you and run those scenarios through your mind. Notice how the positions change, label-wise, but yet the entities are still there, the same entities. Run them through your minds through the week here. And get more tuned into relationships and how to start forming a trust, making sure that you got the evidence. Because if it's all trust, we want to make it sure that we're operating in the trust. So I'm going to call it a night. So if anybody still wants to be on the call later on, I think the call still is open afterwards. So.
Well, thank you.
Thank you.
Yeah, me too. Good night. Thank you.
So I'll see you next week then.
Please, thank you.
Or tomorrow night on Neomorphosis call, let's see.
Alrighty.
We'll have that call tomorrow at 8.
One final question.
Yeah, go ahead.
Okay, when I go down there and they're going to let me put my name on the signature card, all I want to sign that is grantor one.
Oh, yeah?
And then, I'll let them know that they are the trust and I expect them to follow the right procedure. So I don't have to say I'm beneficiary, just grantor set me up perfect.
Yeah, because you could come back in and say, hey, later on, well, here's who the beneficiary is, here's who the trustee is.
Right. So that puts the top as the signed grant.
Uh-huh, right. By grantor and your signature.
Yes, sir. Okay, yeah. By grantor and then my...
Yeah.
If they leave the account open, but they may close the account on you.
Well, I think I could probably stop them from doing that.
As grantors, they're not authorizing things. I don't allow them.
Right. I don't authorize you to close the account.
That's because that's a personal agreement between us.
So now you're going to want to be keeping that original signature card and having them make a copy for their records?
Yeah, that's what I would try to do, yeah. I'd get 2 cards and say I got to, somehow come back in with,
So maybe you see that original card take fill out a deed grantor on it?
Yeah, I would try to do that, yeah.
That would be the smartest.
Yeah, so I could keep the original.
Yeah, and then my dad's Social Security.
Yeah, now if you can't, now what would you do then?
If they will not let me, do that, I just don't see nothing but close.
Okay, I would sign the card with 3 dots and then your signature.
Okay, by that, what will that represent?
The 3 dots represents there's something missing, and then under 3-115, you've got an incomplete instrument that was your intent that later on you're going to add words and numbers to make it complete.
Would that keep closing out exams?
It might, so.
Okay, it would at least throw them a curveball, wouldn't it?
Yeah, because now you got the 3 dots representing the by grantor that's not there that you intend to add later on.
Okay, that does sound really good, and they will know what that means.
Well, it might be enough, to get by that they might not notice it, so they can get the thing in there, and then later on you got the proof.
Yeah, that's another key. Is I need to keep a written to this. I need.
Yes.
Another thing, after you back in to the card.
Right. Mm-hmm.
Codicil. Okay, that could be stated somewhere, couldn't it?
Well, it all comes back down to intent. What did you intend to do? You're the only one. You're the grantor. It's your intent. It all comes back down to intent. Even 3-115 in UCC says, let me see where it says, okay, in A there it says, an incomplete instrument means a signed writing, whether or not issued by the signer, the contents of which shown at the time of the signing that it is incomplete. So there's your 3 dots. It is the signing that it is incomplete, but that the signer intended it to be completed by the addition of words or numbers. It all comes back down to intent.
Okay. Now, when you're saying this, here's what's coming to mind. I need to, when I go in there, have in black and white what mine is to get that signature card, sign it. You'll have all this black and white and sign it the correct way as grantor. That piece of paper is my contract prior to going in there. Then approach them, give it, here's what I want, here's what I'm going to do.
Yeah, see, now, intent demonstrates your actions, but trouble is you might not know or understand what your intent was. Because if you're going by these 3 examples that I gave you, if I give you my pen, I didn't know or understood that it was my intent to form a trust, although a trust was formed here. So there it is. The key is...
My intent is to do what we discussed, and so I need to have it in black and white. So when I get there...
If anybody's not... press 6, star 6, yourself out. Okay, go ahead, Mike.
All right, so if I fill my intent out in black and white, they'll have to follow what I'm saying, won't they? Or won't?
Well, your intent is really demonstrated by your actions. So if you come back in and make your corrections, you're demonstrating your intent.
Okay. I just hope the black and white, you explained it on paper, explain it would have teeth off so they can't go sideways or try to do that or kind of force the contract.
Yeah, well, you could put down on paper one thing and then turn around and contract over it by your actions. So really it's the actions that takes precedence.
Yeah. So it wouldn't hurt for me to write it down, or you think to go in there with what my actions are?
Well, if you had it in writing, they're more apt to say, hey, that's what I can see.
That was my thought.
But it's actually you going in there with the, and making the correction and saying, hey, this is my intent. So your writing and your actions go hand in hand then.
Well, tonight was another real show. It's like every time to learn the elements.
All right, well, I'll see you tomorrow night on Neomorphosis call at 8 p.m. And that number is TalkShoe. So that's 724-444-7444. And the access number is 41875.
Hello, Christian?
Yes.
I'm sorry. I know you're ready to leave. I just wanted to make this comment. I was on a call last night where somebody supposedly got a remedy and through AT&T, and AT&T supposedly sent them a letter stating that their access to their treasury account has been granted and 1 month of the bill has been paid, and then they are going to be looking for 2 more payments in succession of months. I just thought that was, I never heard anybody get a remedy or a letter like that before.
Can you check that out a little bit? Some copies or something?
Yeah, I definitely will. I believe they used the Douglas Riddle process. And, I'm sorry? Okay.
Okay, thanks.
Actually, I heard it on the call last.
What's the Douglas something process?
I think all really too much where he did the payment voucher with just the bottom half of the stub on the back that wrote in the EIN. I don't believe much in front of it. Just put an excessive value on.
Okay, thanks, Harold. Maybe next week we'll bring that up and maybe go over that.
Okay, one last thing. Have you ever checked out the IRS manual or the Internal Revenue, rather?
Have I ever checked out the IRS manual?
No, I meant to say the Internal Revenue Manual.
Two different things, right?
Yes.
No, I can't say that I have, although I might have. You could be looking at something and not pay attention,
Well, the reason why I said that because I believe that you might have through the IRS.
Okay. What you mean, yeah.
Basic couple sections reference how to pay if a certain voucher since it's not effective, how to hit over the effective department and it becomes effective. And it also tells you basically it's going to need overstamp United States Treasury stamp on it for process.
Mm-hmm.
And then also I think that it had non-negotiable on it, that it would not process at all.
Non-negotiable? That's a private site. So is that downloadable off of the web any place from the IRS or?
All you got to do is you go to irs.gov to the Internal Revenue Manual, and that's the first hit to get. And I can actually give you the sections reference that if you like.
Okay, sure, go ahead.
Okay, 3.10.7.7.1, that's acceptable payee.
Go slower a little bit. 3 that again.
Okay.
3.10 what?
0.10.72.7.1. The title, acceptable payees. And you have 3.8.45.4.11, and that section titled questionable payments. 3.8.45.10.1 title is bill of exchange, and then 3.8.45.9.1 is designated payment code. 3.10.72.5.10 is processing, cash, and handling of currency and items of value. Those are all the ones I have for you.
Okay, nothing about non-cash items in there? That last one?
Saying about non-cash items there?
Yeah. Mm-hmm. Would that be in that last section?
I don't recall it. I've read that.
Yeah, because anything that's a non-cash item would be non-negotiable, and that's back office banking, special handling.
Okay. Well, the only thing I can remember was the process, but it does our perfected will process at. There's also changed a couple of the payments as well. Cincinnati, a lot of these codes about to affect them.
Right. And what was the title of the publication again? The Internal
Revenue Manual. And just one last, I believe I was on the Treasury site, was talking about how once the window was closed, I believe you had to open up some kind of account through a bank or something like that. Process FedWire or one of those other they have in order to basically access.
You had to have mail delivery by, I think it was certified mail, I think.
It didn't really say. It did have a certified mail, and certified mail was, it did accept it, but it looked like it really was certified.
Yeah, it was mail delivery was the key. Yeah, seems like that's probably the back office stuff, because that's where you have the multiple packages.
Right. And I know they talked about like that having batch processing like that.
It might, but I don't think so, because everything that's handling is all individual handling.
I remember on that same call last night, they were talking about basically similar to about the private dollar bill with Cabral.
Yeah, Ana Escobedo Cabral.
Yes.
She's on the black side seal underneath the signature.
That's the private side, right?
Yeah, the black side's the private side, which is like in a mirror, it's opposite, because the asset side, the plus side, is on the left. On a regular ledger sheet, it's on the right. So it's like you're looking at it in a mirror.
Now, would you think that might be a place then down to the Puerto Rico office?
Well, it might end up there, but still, you have Geithner and Escobedo Cabral at 1500 Pennsylvania Avenue, all on the same floor, being the same mail drop, just down the hall from one another.
Well, I thank your time, and if you get a chance, maybe you could look at that Internal Revenue Manual.
Yeah.
Maybe while under the process.
Yeah, there was like you mentioned they had to be certified or authenticated.
No, it didn't have to certify, but they do accept it if it was certified.
Oh.
Most of the mail can come regularly. And then also, if I'm not mistaken, at certain time periods, certain mail is pushed aside, and that could probably delay that everybody, and then they pick up after, certain time, of course, like teen tax period, that they only focus certain mail in subject, and then pick up on these remittances.
Mm-hmm. But what you said earlier about some kind of certification, you didn't say certification, but it kind of reminded me of the Wizard of Oz. When Dorothy came in, she killed the witch when the house fell on the witch. But then the mayor of the town said, you've set us free. We're going to declare our independence. But somebody came up and said, well, we have to absolutely certify that she is dead. And then the undertaker came up and said, I've examined her and here's my certificate of death. So they had to certify her death first before they could declare their independence. Declaration of Independence. So it sounds like we got to get our records certified, cleared up first, maybe declare our independence. But what you said there kind of reminded me of that. You said that some of those instruments had to be, it wasn't certified. You didn't use certified, but you said something else.
Yeah, well, they said there was a section that discussed if the mail was certified and how to process.
Well, this wasn't going by mail delivery, being certified mail. It was the certification of something if it needed it, you said. But you didn't use the word certify.
I'm sorry.
It was like authenticate maybe or something like that, or it had to make sure it was authentic. And that way they had to get some kind of, you said, a seal on it?
I was talking about it.
No, before that. Just about when you first came on there and started explaining, oh, well, they might not remember, but...
Yeah, I'm sorry. I'm sorry. My thought is not right.
My mind went to the Wizard of Oz, when it had to be certified. So it's kind of like that banker's, what's the seal they put on that? I forget the thing.
Medallion?
The medallion, yeah. The medallion.
I've just found the website for Douglas Riddle, if anyone wants the URL.
I'm sorry?
I've just found the website for Douglas Riddle. You mentioned?
Yeah.
What is the website?
It's CATSA4V.
I believe he actually has like a photocopy of the actual document, however. I think he does it all right. And actually, now I think about it, I know that in one of the sections it says that they don't take photocopies of documents, but, basically says the document came $1,000, and he goes to a certain department, and $1 a certain person.
Yeah, he's
interesting.
Talking about a lady called Annie Martinelli, or Anne Martinelli.
Oh, yes. Exactly talking about it.
Yeah, it's all there on the site. So it's CATSA4V.
What was the last part? CATSA.
So it's CATSA4, the number 4, then V dot Homestead HOMSTEAD.com/Douglas with a capital D hyphen Riddle with a capital R spelled RIDDLE .html.
The name of that call that I want to talk to, valid discussion. It was last night's call. It's my first week about processing that letter.
Do you remember the?
Yes, the call number ID 54318 1220. It was the first hour of the show. The show was half hour, so right.
That number again was 54318?
Yes.
Okay.
Was that a public?
I'm sorry, 5433188. Did I get that? No, it was right the first time. I'm sorry. Take off that last thing.
Okay, anything else?
Well, thank you again for listening.
Hey, as long as we all share information. Hey, I'm glad to see some people out there doing some research and digging around and,
Yeah, there was one thing. My friend kind of chased up his mortgage. He was looking for the note, and he asked them to produce the note. He got a letter back today, and it said something about who the beneficiaries are. He wasn't too clear. He didn't have much time to explain, but it did state beneficiaries on the thing. So he's now going to quiz them who gave authority to appoint the beneficiaries, and how it came to be on the letter that he's received from them. So I'll keep you updated on that too.
All right. Okay, with that, I'll either see you tomorrow night or Saturday or next week.
Tomorrow night.
Okay. This call number will probably be different next week on next Tuesday's call. We're probably going to go back to that original number, that 605 number. I couldn't get it corrected in time, so that number's
question. I'm sorry. My name's Mark. I'm not Massachusetts.
Okay. All right.
Could you just repeat that number, please, Christian? We don't have it.
Okay. It was the same one. It was at the top of the screen, but we had to dial in on the 702 number last week. And that was the same number that we dialed in this week, 702. But the 702 number will change, and the new number is going to be 605-715-4949. And it'll still be the same PIN number, 668464 pound.
Thanks very much.
Yeah, I was going to, that number is in existence right now. In fact, I had made it a simultaneous number, but I figured I didn't have enough time to identify it to everybody, so figured I'd just hold it on the same number we had this time, and then next week we'll jump over to the 605 number.
Yep.
Okay. Yeah, well, I've got all these features. I got these widgets. I'm trying to put up a website on maybe Facebook and put the widget up there, and then everybody could go to the widget and just sign in through the widget and get into the call. Well, I could use MySpace. How come? I could go on Microsoft or something like that, or Google, build a website there, I guess. Same problem, though, I guess.
Yeah, they're everywhere.
Yeah. All right, well, I'll see you all next week or tomorrow.
All right, again.
All right, night.
Good night.